host for today, Courtney Buchan. Thanks for having us.
Thank you, Jeff, so much. So my name is Courtney Buchan. I'm with GRS Community Management. I am the corporate trainer. I'm a licensed community association manager, and I'm also a board member on my board. So I'm having fun over here, all about community association management. GRS is a mid-sized community association management company located out in Lake Worth, Florida. We service all of the great state of Florida. We have multiple properties throughout Palm Beach County, on the West Coast, Broward County, so on and so forth. I know we have some of our GRS community managers here today. Welcome. Hello, guys. Thank you for joining. And I'm hoping we have some of our GRS board members on today. If you're interested in new management services, you can contact me at cbuchan@grsmgt.com, or you can follow us on any of our social media accounts. We have Facebook, LinkedIn, Instagram, X, all those wonderful things. So again, thank you all for joining today's webinar presentation, Navigating the FFHA Assistant Animal or Pet. So today, Danielle's joining us from Kaye Bender Rembaum. Thank you so much, Danielle, for providing today's webinar. Danielle works out of Kaye Bender Rembaum's Palm Beach Gardens office. She's board certified in condominium and plan development. I haven't had the pleasure of working with you yet, but I've seen some of your presentations. Very, very knowledgeable. Kaye Bender Rembaum, they do the most on board and manager education. If you haven't attended one of their classes, and this is the first one, welcome. They are always doing classes. Sometimes they have multiple classes in a day. They recently just sent out, for all of you board members needing certification, condominiums. They do have a new 4-hour board certification class for condos. I think you said that was September 19th?
September 19th, yes. I believe it starts at 11 a.m. And it'll be myself and my colleague, Andrew Black, out of our Pompano Beach office, giving that class on the 19th, excuse me, September 19th.
So if you are a condo board member that needs certification, definitely check that out. Check Kaye Bender Rembaum's website out. It's kbrlegal.com. They have a whole calendar of events. You can join or register for those events, and they'll have previously recorded webinars. There's no credit for those, but you can watch them, like today's event. That's where you'll find the recording in a few days on their website. So once again, thank you, Jeff. Thank you, Danielle. So Danielle is going to start talking about navigating the FFHA. So that's the Federal Fair Housing Act, and then assistant animal or pet. So there's really two types. There's service animals and emotional support animals. There's a big difference there, so definitely pay attention, especially if you're on the board and you've gotten that question. What can you say to an owner? What can you say to a tenant? Can you ask for documentation? Those are all really important questions that Danielle will be answering today. So with that being said, I'm going to turn it over to Danielle, and let's get ready to learn.
You've said so much of what I'm about to say. I mean, come on now. She knows her stuff.
Trying to help you out.
Thank you, Courtney. Thank you. And thank you, GRS Community Management, for having me here today to talk about everyone's, let's say, second favorite next to structural integrity reserve studies topic, assistance animals under the Fair Housing Act. Like Courtney said, my name is Danielle Brennan. I am an attorney out of the Palm Beach Gardens office. I am board certified in condominium and plan development law. I am one of the 21 attorneys with Kaye Bender Rembaum. We have 4 different locations, the Palm Beach Gardens office, which is where I'm located out of, the Pompano Beach office, which is where Andy Black, who will be doing the condo certification course with me next month, is located out of. We also have offices in Tampa, an office in Winter Park, and throughout Miami-Dade by appointment only. This is what we do day in, day out, provide representation to community associations throughout the state of Florida. And we're experts at it. We can say that because we are board certified by the Florida Bar. And this is something that we love doing. It's a mix of everything. You know, a lot of people will say, oh, you guys are real estate attorneys. Well, no, not really, because here we are talking about assistance animals. So there are so many different aspects to this, and I definitely encourage everyone to not only go to your board certification courses, but to attend things like this that really drill down into the more specifics of the areas that get touched on in those board certification courses. So let's go ahead and dive right into it. Before I do, just a little disclaimer, this is not legal advice. I am an attorney and I do provide legal advice to our clients. This is informational only. If you're looking for legal advice and you need an attorney, contact Kaye Bender Rembaum. We'd love to have you. You can go to our website, like Courtney was saying, we've got some great resources there as well, in addition to all the courses for the events, like the legal update that Jeff was talking about earlier that you'll have the link to receive. That's also on our website. So lots of a wealth of information there. And if you need to contact us to provide you with specific legal advice for your community association, please do. All right, so now I'm going to share my screen so that we can get going with the PowerPoint presentation. And maybe this will begin from the beginning. Okay, here we go.
Perfect.
All right. So in the United States, we know we have our federal government, we have our state government. The Fair Housing Act has multiple levels. Today, we're really focusing on that federal level. And it's the policy of the United States to provide within the constitutional limitations for fair housing throughout the United States. Now, the Fair Housing Act is enabled by the Department of Justice and the Department of Housing and Urban Development, which is referred to as HUD, and you'll hear me refer to it as HUD throughout. These are the main bodies, but HUD is usually the one who's doing the heavy lifting here. The Fair Housing Act prohibits discrimination in housing on the basis of race, color, religion, sex, national origin, familial status, which is really age. It's mainly discrimination against children, and disability. Now, these are the federally protected classes under the Fair Housing Act. There are also state and even local counterparts that may provide for additional classes. The state of Florida, our fair housing laws are in Chapter 2 or Part 2 of Chapter 760 in the Florida statutes. And then in Palm Beach County, in our code, we also have protected classes based on sexual orientation, age, marital status, gender identity, or expression. Now, when it comes to assistance animals, we're really just focusing on disability, but just know that the Fair Housing Act does have a much further reach than just disability and assistance animals. It touches upon all types of different discrimination in housing. So where does this law come from? Well, the law in and of itself comes from the US Code, and the agencies that are created under the code have been enabled to adopt different administrative regulations in the Code of Federal Regulation. United States Code is enacted by Congress, similar to our Florida statutes that's enacted by the Florida legislature. The US Code is enacted by the federal government Congress level. And the Code of Federal Regulations are similar to our Florida Administrative Code, where they're adopted by governmental agencies who have that enabling authority in the code itself or the statute itself. And here's a little breakdown of what you can expect to see in the Code of Federal Regulations regarding the Fair Housing Act. So the Fair Housing Act prohibits housing providers from discriminating against housing applicants or residents because of their disability or the disability of anyone associated with them. Again, just a disclaimer, we're focusing on disability today, but Fair Housing Act covers a whole lot more than just disability. The Fair Housing Act prohibits treating persons with disabilities less favorably than others and makes it unlawful for any person to refuse to permit, at the expense of that disabled person, reasonable modifications of the existing premises occupied or to be occupied by that disabled person if those modifications are necessary to afford that person full enjoyment of the premises. And it also makes it unlawful for any person to refuse to make reasonable accommodations to rules, policies, practices, or services when those accommodations are necessary to afford a disabled person with equal opportunity to use and enjoy a dwelling. Now, Fair Housing Act, again, covers so many things more than just disability, but today we're focusing on disability, and it also provides for reasonable modifications and reasonable accommodations, but for today's purposes, we're really going to be focusing in on reasonable accommodations to things such as pet prohibitions or pet limitations, such as weight, what have you, number. There are certain exceptions where the Fair Housing Act is not going to apply. Membership in a religion, religious organizations, they have certain ability to impose certain qualifications for membership. Private clubs also can impose certain limitations for membership. When it comes to familial status, there are certain communities that are exempted from the familial status discrimination class because they're either 55 and older communities or 62 and older communities. And I'm sure being in South Florida, we're very familiar with the 55 and over landscape. The Fair Housing Act does not prohibit conduct against a person because that person has been convicted by a court of the illegal manufacture or distribution of a controlled substance. But note that if someone is recovering from use of controlled substances, they may be a protected class under the Fair Housing Act. And there are certain real estate transactions to which the Fair Housing Act would not apply. But for our homeowners associations, condominium associations, other property owners associations, we are going to be subject to the Fair Housing Act. And they refer to, the Fair Housing Act refers to those who are subject as housing providers. Now, you'll often hear someone say, oh, my animal is permitted under the Americans with Disabilities Act, and you have to let my animal in under the Americans with Disabilities Act, the ADA. Well, that's not necessarily true because the ADA is really only applicable to public spaces, areas of public accommodation, whereas our residential communities are private. So while there is quite a fair amount of interplay between the ADA and the Fair Housing Act, they are applied to different spaces. ADA prohibits discrimination based on disability only, whereas, as we've mentioned before, Fair Housing Act has so many other different classes that are protected under its laws. ADA, again, public accommodations, employment, transportation. Those are the areas in which the ADA will apply, whereas Fair Housing Act, it's for private housing, federally assisted housing. The ADA, it only covers one specific type of animal, and that's a service dog. Whereas Fair Housing, we provide for assistance animals, which includes the service dog and also support animals, otherwise referred to as emotional support animals or therapy animals. And we'll get into exactly what those animals are in a little bit. Both prohibit discrimination based on disability. Both provide for animals that assist with the disabled. Both allow for accommodations to policies and modifications to physical facilities. They both use a different term for a disabled person being disability or a handicap, but there's essentially the same exact definition for both. And both can apply depending on particular circumstances, such as a community that has a golf course or a country club that's actually open to the public for public membership and access and use. Again, they use different terms, but a rose by any other name has the same, still smells as sweet. Handicap and disability, they are used interchangeably and defined very similarly. Handicap. So what does it mean? The term handicap means, with respect to a person, a physical or mental impairment which substantially limits one or more major life activities. This is the definition that is most often used with regard to determining whether someone is handicapped or disabled. There are other aspects to this definition, however. A person having a record of such an impairment or being regarded as having such an impairment. The term handicap meant before we were mentioning the manufacture and distribution of illegal substances is not applicable under the Fair Housing Act. What's also not applicable would be the current illegal use of or addiction to a controlled substance. But again, if they're recovering from it, they may be protected under the Fair Housing Act. So when we're going to break down that first portion of the definition, a physical or mental impairment that substantially limits one or more major life activities. So what is a physical impairment? Well, as you can see from this slide, it could be any type of mental, emotional, psychological disorder, affecting your heart, your liver, anything really. Autism, epilepsy, muscular dystrophy, multiple sclerosis, cancer, heart disease, emotional illness. It could be anything. So what's a major life activity? Again, there's a list here, but it's not an exhaustive or exclusive list at all. So the term major life activity means functions such as caring for oneself, performing manual tasks, hearing, speaking, breathing, learning, working. Could also be anything. Now that's the first part of the definition of handicap. Now breaking down the other two parts of it, having a record of such impairment means a person having a history or record of or has been classified as having a mental or physical impairment that substantially limits one or more major life activities and is regarded as having an impairment. That third portion of the definition means that the person has a physical or mental impairment that does not substantially limit one or more major life activities, but that's treated by another person as constituting as having such a limitation. Or the person has a physical or mental impairment that substantially limits one or more major life activities only because of the attitudes of others towards that impairment. Or the person has none of the impairments but is treated by other people as having such an impairment. So the lesson here being, be careful what you say, because what you say couldn't create this person as being regarded as having an impairment that could mean that they are in fact disabled for the purposes of the Fair Housing Act. Now recall we were talking about reasonable accommodations and reasonable modifications, just a little bit more information as to what these in fact are. A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service, whereas a reasonable modification is an actual physical structural change that's made to the premises. Now, depending upon the disability, a person may need either a reasonable accommodation or a reasonable modification or both in order to have an equal opportunity to use and enjoy a dwelling. Now, you hear that phrase a lot, use a reasonable equal opportunity to use and enjoy the dwelling. Well, it doesn't mean that it is limited only to the dwelling. It also means those services and amenities that are associated with that dwelling, which would include your common areas, your common facilities. It is unlawful for any person to refuse or to make reasonable accommodations in those rules, policies, practices, or services when that accommodation may be necessary to afford a disabled person with equal opportunity to use and enjoy the dwelling, again, which includes those public and common use spaces. And for assistance animals, requests are made for reasonable accommodation to an association's pet restrictions or even pet prohibitions so that that disabled person can have an assistance animal within that community. Now, really honing in on reasonable accommodations, like I said, we're going to be talking about disability and reasonable accommodations under the Fair Housing Act, as those two things relate specifically to assistance animals. Now, the Fair Housing Act does not require that an association adopt any forms or procedures for reasonable accommodations requests. However, having those formal procedures and forms can help the association and the disabled person in reviewing the request, providing the information that's actually needed in order for the association to review and make a meaningful review of the person's requests, and can also create a record to show that requests receive the proper consideration, that the proper documentation is obtained to support the granting of the request or the disapproval of the request. The association can make the truth and accuracy of the information provided as part of the process when they're bringing in, doing their intake, if they have an approval process for their tenants or for their new owners in the community. You can require truth and accuracy of that information. A housing provider, though, cannot refuse a request because the person making the request didn't follow those formal procedures that the provider has adopted. So even if the association has the form and has specific processes in place, even if that person does not fill out that form, follow those specific processes, the association still has to consider the request and review it as if they had done all the proper steps, because there's nothing in the Fair Housing Act which would require the person to follow those procedures. So you can't say, no, you can't have your animal simply because they didn't fill out and submit the form. Notwithstanding that you can't force the form, they do still have to make the request. A disabled person is not entitled to receive a reasonable accommodation unless they request one. And the Fair Housing Act does not require that a request made in a particular manner or a particular time. Again, they don't have to fill out a form. This means that, they could bring the animal into the community and then make the request. They don't have to make the request first and then wait for the approval before they bring in the animal. A person with a disability does not have to make the request on their own behalf. Somebody else can make the request for them. And they don't need to use the words Fair Housing Act or reasonable accommodation. It's just that the person who makes the request has to do so in a manner that a reasonable person would understand that the request is for an exception, change, or adjustment to a rule, policy, practice, or service because of a disability. So there are no magic words that they have to use in order to trigger the association's obligation to treat the request like a request for a reasonable accommodation under the Fair Housing Act. And again, the request can be made at any time, even after the resident has brought the animal into the community. So a little bit of history. A while back, we were reviewing and analyzing requests we received for assistance animals the same, regardless of whether they were a service animal or a support animal. And we had heard through the grapevine that the HUD was going to be issuing new guidance to provide clarity for different housing providers to better be able to evaluate these types of requests. And we were all like, hooray, yes, this is awesome. We're going to get the information that we need to, cut back on the abuses of this process. Well, then January, I don't remember exactly the day, but it was 2021, the guidance was issued. And instead of it being the clawback that we were hoping for, it in fact just made it a little bit easier, in our opinion, to get these animals into your no pet communities, and definitely change the manner in which the service animals are treated as opposed to the support animals. So that's why it's very important to figure out what type of animal it is first. Is it a service animal or is it a support animal? So a service animal, this is where we kind of incorporate portions of the Americans with Disabilities Act into the Fair Housing Act. Under the ADA, a service animal is defined as a dog that's individually trained to do work or perform tasks for the benefit of a disabled person, including a physical, sensory, psychiatric, intellectual, or other mental disability. Note that performing work or tasks means that the dog is trained to take specific action when needed to assist the person with the disability. Again, it has to be a dog, cannot be any type of other animal, wild or domestic, trained or untrained. Doesn't matter if it's not a dog, it is not a service animal. And the work or task performed by a service animal must be directly related to the individual's disability. There's got to be that nexus there between the disability and what they are trained to do. Emotional support, comfort, well-being, companionship, these are not work or tasks for the purposes of a service animal. So your therapy dog or what have you is not a service animal under the Fair Housing Act. So we can necessarily weed out a lot of the different or determine if an animal could be a service animal or a support animal by looking at the type of animal. Is the animal a dog? If it is, well, then it could be a service animal. If it's not, it's definitely not a service animal, though it could be a support animal. Now, is the animal being requested as a service animal? Well, is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? This is us looking at the situation and trying to see, what do we already know? It's readily apparent when a dog is observed guiding an individual who's blind or has low vision, pulling a wheelchair, providing assistance with stability or balance to an individual with an observable mobility disability. If it's readily apparent, well, then you don't have to ask any more questions. That animal is a service animal. If not, then we ask ourselves, okay, well, is the animal required because of a disability? Well, if the animal is required because of a disability and there is a work or task identified, again, that's not providing emotional support or for companionship, well-being, any of that, then you would grant the request if otherwise reasonable, because the animal is a service animal. If not, well, then the animal is not a service animal, but it could be a support animal. If there's at least one action that the dog is trained to take that is helpful to the disability, the dog should be treated and considered as a service animal. If there's no specific action, well, it's not a service animal, but it could be a support animal. Now, what is a support animal? If an animal's not a service animal, could be a support animal. It's an animal that is trained or untrained. Remember, this is a big difference between a service animal and a support animal. Service animal has to be trained, whereas a support animal can be trained or untrained. Doesn't have to be a dog, can be any type of other animal that does work, performs tasks, provides assistance, and or provides therapeutic emotional support for a disabled person. Again, they're not required to be dogs. They can be any animal commonly kept in households, like a cat, turtle, rodent, fish, or it could be a unique animal that's not commonly kept in households. But there are certain requirements for that we'll get into in a little bit. Now, when we're looking at a request for a support animal, we really have to check two boxes. Is the person disabled? Is there a disability-related need for the accommodation for the assistance animal? Again, we're asking ourselves, well, what do we already know about this situation? Does the person have an observable disability, or does the association already have information giving them reason to believe the person is disabled? Well, if you do, we've already checked off that disabled box. Then we need to go on and ask about the disability-related need for the assistance animal. If not, well, then we're going to ask for some documentation, right? And then we'll get into that next. Observable disabilities include blindness, low vision, deafness, mobility impairments, certain neurological impairments, mental illness, other diseases that affect major life activities or bodily functions that are readily apparent by looking at someone. If the person has requested the accommodation, if they provided information that reasonably supports the person has a disability, well then, okay, they are considered to be disabled, and then we can move on to the disability related need. If not, then the association is not required to grant the accommodation, but the association needs to start doing some digging, right? The association has to provide the person requesting the accommodation with a reasonable opportunity to provide information that reasonably supports that the person has a disability. So what can we ask for? Information about the disability can include a determination of disability from a federal, state, or local government agency, receipt of disability benefits like Social Security, Medicare or supplemental security income for a person under age 65, eligibility for housing assistance or a housing voucher received because of a disability, or what you see most commonly, information confirming disability from a healthcare professional like a physician, optometrist, psychiatrist, psychologist, physician's assistants, nurse practitioner, or nurse. A determination that a person does not qualify as having a disability for the purposes of a benefit or other program doesn't necessarily mean that the individual does not have a disability for the purposes of the Fair Housing Act or under the Americans with Disabilities Act. That information can still be provided by a healthcare professional. Now, in certain instances, there are some types of impairments that are going to be found a disability, such as deafness, blindness, intellectual disabilities, autism, cerebral palsy, epilepsy, major depressive disorder, bipolar disorder, schizophrenia. These impairments in virtually all cases will be a disability. So now that we've got some documentation about the disability, and we've determined, okay, the person is disabled, we'll talk some more about some additional information. We then have to ask ourselves, has the person requesting the accommodation provided information which reasonably supports that the animal does work, performs tasks, provides assistance, and or provides therapeutic emotional support with respect to the person's disability? If yes, oh, well then, fine. They can have their assistance animal, their support animal. The only other questions we really have to ask at that point are related to whether or not the animal is a unique animal or a common household type of animal. If not, then the association is not required to grant the accommodation, but the association has to enter into an interactive process. Now we need to get some more information. The association has to provide the person requesting the accommodation with a reasonable opportunity to provide the information that reasonably supports that the animal does work, performs tasks, provides assistance, or provides therapeutic emotional support with respect to their disability, right? We can ask for certain information to establish the disability related need for the assistance animal. Now, this information often consists of information from a healthcare professional, and we've talked about before, physician's assistants, nurse practitioner, nurse. It's always going to be general to the condition, or I should say, it only needs to be general to the condition, but specific to the individual and the an animal, the assistance provided by the animal. So we don't have the right to know the nature or the severity of the disability, but we do have the right to know that the person has a disability and has a disability related need for the accommodation. There has to be a relationship or connection between the disability and the need for the assistance animal, particularly where the disability is not readily apparent to us. For non-observable disabilities and animals that provide emotional support, the association can ask for information that is necessary to conduct that individualized assessment of whether it has to provide the accommodation. But again, lack of the documentation in many cases, but not all, may be reasonable grounds for denying a requested accommodation. Again, this is very gray area, and always suggest going into that interactive process to get the information that the association needs in order to provide a meaningful review of an applicant's request. With that January 2021 guidance HUD issued what they refer to as guidance on documenting an individual's need for assistance animals in housing. And it's like 4 or 5 pages that we would typically enclose into a letter requesting additional information to say, oh, here's what HUD provides to give you a little bit of insight, more insight as to what we are requesting to receive, so that we actually get the information that we need in order to evaluate the request. Now, internet documentation, we see it all the time, where somebody takes a picture or sends us a scan of their identification card or their certificate saying that Fluffy is registered with the United States Registry of Assistance Animals or Registry of Emotional Support Animals. Here's her registration number, handler is the applicant's name, what have you. Now, I mean, these people are obviously making money off of these registries because the certificate or the registration in and of itself does not substantiate the need for an assistance animal. Obviously, they're selling these things so that you can provide them, but ultimately, they're not going to win the day unless you're providing additional information, or unless, your disability or disability related need is already apparent or known to the association. This internet documentation is not in and of itself sufficient to reliably establish that a person has a disability or disability related need for an assistance animal. However, there are certainly ways that a person can obtain sufficient documentation through the internet, such as telehealth. You could be seeking therapy or emotional support, mental health support from professionals through telehealth, and be able to get documentation that way. And that certainly may provide the substantiating information that the association would need in order to review the request, providing meaningful review of the request. But yeah, we see them all the time. And when we send letters back to the applicants, we'll say, thank you so much for providing this. However, this isn't something that's necessary for the analysis under the Fair Housing Act. Now, these documents that we receive, yes, they are absolutely official records of the association. However, Florida statutes provide that members cannot inspect official records that include information obtained in connection with the approval of a lease, sale, or other transfer of a unit or parcel, or medical records of unit owners, parcel owners, community residents, or their sensitive and personal information like social security numbers, driver license numbers, and other personal identifying information. All of that, although it's official records of the association, they are not accessible to members through inspection. So recall that we were talking about unique animals and the possibility that the assistance animal, specifically the support animal, could be an animal that's not commonly kept in a household. If it is, and it's ticked off the boxes of, okay, applicant is disabled and has a disability related need for the animal, well then fine, they can have their animal. If not, the association is not required to grant the accommodation, except in these certain circumstances. If the individual is requesting to keep a unique animal, then the requester has the substantial burden of demonstrating a disability-related therapeutic need for that specific animal or that specific type of animal. They're encouraged to submit documentation from a healthcare professional confirming the need for that particular animal. For example, that allergies prevent the person from using a dog, or without the animal, the symptoms or effect of that person's disability will be significantly increased. This is an example that's actually provided by HUD in its guidance. An individually trained monkey performs tasks for a person with paralysis caused by spinal cord injury. The monkey has been trained to retrieve a bottle of water from the refrigerator, unscrew the cap, insert a straw, and place the bottle in a holder so the individual can drink and can switch lights on and off and retrieve requested items from inside cabinets. The unique animal is permitted because the monkey can use its hands to perform manual tasks that a dog cannot perform. So there may be instances in which you could be granting a request for a monkey. But speaking of water, since I've been speaking for so long, this monkey will grab her water.
Yes, have a sip. And I'll just, while Danielle's quenching her dry throat for a second there, it's a lot of talking. Thank you. I just want to mention, be sure y'all stay on at least until we get to the Q&A, because at that point is when we'll put the evaluation into the chat area. So again, if you don't yet see the chat area, please click the chat button at the bottom and it will appear, because we will soon be placing a link in there. Back to you, my friend.
Alrighty. So moving on. Now, there are certain instances in which the association is not required to grant the request. One of them is if the animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through actions the individual takes to maintain or control the animal. So these are animals that we know have a vicious propensity that can't be managed by having a muzzle or having them within a secure enclosure or something like that. This determination has to be based on an individualized assessment of that particular animal. It cannot be mere speculation or fear about the types of animal. I know a lot of people can be afraid of dogs, or a lot of people have different, have negative opinions about certain breeds of dogs like pit bulls. But the direct threat really has to be individual to that animal, not on a generalized stereotype basis. You've heard me say a couple times, interactive process, interactive process, interactive process. If there is something that the association has a question about, or it doesn't know certain aspects, doesn't know the person is disabled, has a question regarding the disability related need for the animal, the association cannot deny the request because they're uncertain or they don't know something. They have to enter into this interactive process where they go back, they ask for additional information, and enter into a good faith dialogue with the person requesting the accommodation. The association cannot insist on specific types of evidence if the information provided or actually known to the housing provider meets the minimum requirements of the Fair Housing Act. So this is a delicate process. Disclosure of details about the diagnosis or severity of a disability or medical records or medical examination can't be required. Again, this goes back to the association not being able to have the information regarding the nature or severity of someone's impairments or disability, but knowing that the information is specific to that person and to the animal, the disability related need for the animal. So if a housing provider, if the association lawfully refuses a requested accommodation because the request is not reasonable, maybe the animal presents a direct threat, the association should consider and discuss with the requesting party alternative accommodations that would address their disability related needs without fundamentally altering the provider's operations. Now you see fundamentally altering, Danielle, wait a second. We are a no pet community and we have to let this animal in. This is a fundamental alteration of our operations. Well, not according to the Fair Housing Act. Allowing the animal provides the disabled person with the equal opportunity to use and enjoy the dwelling and the services that are associated with the dwelling. So fundamental alteration really here is talking about the direct threat presented by the animal, the specific animal. If there's an alternative accommodation that would effectively meet the requesting party's disability related needs and it's reasonable, then the association has to grant it. Now, there are certain things that we certainly can't do. The association cannot require applicants and residents to pay a deposit for an assistance animal or to pay an extra fee as a condition of receiving a reasonable accommodation, even if that charge or that fee is charged for pets. Certainly the person would be responsible for any damages caused by their animal, but the association can't take a deposit as security to then pay for whatever damages might occur. The association cannot ask someone to provide access to their medical records or medical providers or to ask for detailed information. Again, this is going to the nature or severity of someone's disability. And the association cannot unreasonably delay a response to a reasonable accommodation request, as an undue delay in responding could be deemed a failure to provide a reasonable accommodation. Essentially, it's equal to an outright denial. And based on the January 2021 guidance published by HUD, this reasonable time is about 10 days, which is fairly quick. So now that we have assistance animals in our communities, where can these assistance animals go? Well, a disabled person is responsible for feeding, maintaining, providing veterinary care, controlling the assistance animal. They can do this on their own or with the assistance of family, friends, volunteers, different service providers. Maybe they have a dog walker that comes into the community. Fine. The association has to modify or provide an exception to its no pets rule or policy to permit a person with a disability to live with the animal. So they're going to be able to go into the person's home or to their unit and use the animal in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial or administrative burden or would fundamentally alter the nature of the housing provider services. So assistance animals can go essentially wherever the owner or the resident can go. There are public health laws that would prohibit the dog from actually going into the pool, but the dog would be allowed to be with the person on the pool deck. If your community has a bistro or a restaurant, cafe, what have you, the animal can go into the guest service area with the person while they're eating, but wouldn't be permitted to go into the kitchen where that owner is usually, not permitted to go, and there are health laws that would prohibit that. So it's not absolute, but for the most part, the animal's going to be able to go wherever the owner can go. Now, we do have associations that come to us and ask and say, listen, this is getting out of hand. We have all these animals in our no pet community. We need to create some rules to rein this in. Now, conditions and restrictions that apply to pets, they are not going to apply to your assistance animals whatsoever, such as weight restrictions, breed restrictions, side restrictions, number restrictions. It's not going to matter. But given that the board generally has the authority to promulgate rules and regulations, again, you're going to want to check your governing documents to make sure that you have this authority. The board has limited ability to adopt rules and regulations applicable to the assistance animals. However, it's certainly not clear whether this is entirely acceptable, to have assistance animal droppings picked up by the disabled person. There may be an instance in which these particular rules would also require an accommodation, such as somebody who is blind, who can't possibly see what it is that they are picking up, or the reasonableness of these rules really needs to be analyzed by your association's lawyer. And you're going to have to provide additional accommodations if there's a disability related need for that, notwithstanding that these rules may specifically apply to assistance animals. Now, when it comes to your pet restrictions, let's say you're not in a pet prohibited, but you're in a pet restricted community. That assistance animal does not count as a pet. They are not pets. They're animals that do work for a person with a disability. So they're not counted toward the number of allowable pets. If 2 dogs are allowed and the request for an assistance animal is substantiated, then the owner could have 3 dogs comprising of 2 of their pets and 1 assistance animal. So that's basically the nitty-gritty of reviewing and analyzing a request for an assistance animal in our pet prohibited or pet restricted communities. Now, what happens if well, let's say the association may make a mistake, or it is perceived that the association has made a mistake and violated the Fair Housing Act. Well, the plaintiff, being the person against whom the action was taken, can establish a clear claim under 3 separate theories. One being intentional discrimination, which is something I hope everyone would avoid. Disparate impact, meaning something which looks totally neutral and objective on its face actually has a greater impact on a specific set of people who are within a protected class. So the popular example is using a stated credit score for applicants coming in to purchase homes, where historically and statistically speaking, people of minorities would be much more heavily affected by that type of seemingly neutral requirement of the governing documents, and therefore it creates a disparate impact on that protected class. And lastly is the failure to allow a reasonable accommodation or modification. So there are a number of avenues and venues to bring the complaint, but for the most part, you're going to see them come from administrative agencies because it's much cheaper for the person who's bringing the complaint to file the complaint with HUD, who then takes it upon themselves as like a matter of protecting the public to then see the investigation and potential violation of the Fair Housing Act through. So that is at the federal level. HUD is at the federal level. There are state agencies as well. In Florida, we have the Florida Commission on Human Relations. And then there are also local agencies that will take the complaint and do the investigation. In Palm Beach County, we have the Office of Equal Opportunity. There is also the option to go to court for a judicial determination. They don't have to seek relief from an administrative agency before they file a lawsuit. They could just go ahead and file the lawsuit in federal court. A complaint that's been brought to HUD can still also be taken to court so long as there's not been a conciliation agreement, and we'll talk about what that is in a minute. And there hasn't been an administrative law judge that's started a hearing, so there's still the opportunity for them to go to court. Of course, this is going to be the more expensive option. You're going to have a higher, attorneys, and you're going to incur court costs. Now, the division, meaning the Division of Florida Condominiums, Timeshares, and Mobile Homes, they will not hear fair housing violation claims. The claimant will then be instructed to file a complaint with the administrative agency and provide proof of that filing for a stay of the arbitration. If you happen to bring in a fair housing complaint, perhaps with some other complaint that might be within the jurisdiction of the division, like material alteration. So let's say that the complainant brings their complaint to HUD. Well, the complainant and the association will have the opportunity to conciliate, which is their fancy term for settle the dispute during HUD's investigation of the matter. If HUD finds that there's a reasonable cause that discrimination in fact occurred, the case will go before the administrative law judge within 120 days, or either party can then elect, like we talked about before, to take it to court. A HUD or a DOJ, the Department of Justice decision, not to proceed with a fair housing matter doesn't mean that the complainant can't then go file a private lawsuit. If the case is heard by the administrative law judge and the administrative law judge presiding over the case determines that discrimination occurred, the association can be ordered to compensate the complainant for their actual damages, including humiliation, pain, and suffering, provide injunctive or other equitable relief, for example, to make the housing available to the complainant, to pay the federal government a civil penalty to vindicate the public interest. This is a just pure penalty here. Maximum penalties are $16,000. For a first violation, $65,000 for a third violation within 7 years, and to pay reasonable attorney's fees and costs. Now, if the matter is taken to the federal district court, within 20 days of HUD issuing a charge that it is found reasonable cause, the party can take it into federal district court. Within 30 days of doing so, the Department of Justice will file a lawsuit and litigate on the complainant's behalf. And the federal district court can order relief and award actual damages, including attorney's fees and costs. And they can also award punitive damages. Again, they want to be sure that the association is penalized so that doesn't happen again. The complainant can, at their own expense, file with the district court within 2 years of the alleged violation, so long as they've not signed the settlement agreement, the conciliation agreement, and the administrative law judge has not begun an administrative hearing. Again, actual damages, punitive damages, attorney's fees, and costs are all things that can be awarded here. Now, we're going to go into some cases of interest and some little examples that are provided by HUD. I'm going to try to go through these quickly because I know that we're approaching the end of our course. In this particular case, really, it's just showing that directors do have personal liability if there's discrimination found. In this case, it was clear that the board members had done discriminatory conduct, and the court denied the defendant's motion to dismiss. So essentially allowed the case to move forward. The plaintiffs alleged that each member of the board was personally involved in each and every discriminatory act mentioned in their complaint, and that each board member was personally intentionally discriminating against these families. And you can certainly read, Google the case if you wanted to know the particulars here. But in this instance, Chapter 617 did not protect them. Chapter 617 being the Not-for-Profit Corporations Act did not protect them from liability here. So these particular cases that I'm about to dive into, these are specific to assistance animals, and I always give this disclaimer. These cases were decided before the January 2021 guidance was issued by HUD. So these are all cases that were analyzed on prior guidance, which no longer exists and has been superseded. Also, in order to get to this place, meaning a judgment in favor of the association, they had to gamble. They made a hefty gamble that certain information was going to come to light in discovery so that they could prevail on their claims. This may not be a gamble that your association wants to take. All right. So in this particular case, again, is in 2009, well before the 2021 guidance was issued by HUD. So just take these with a grain of salt. In January 2025, Han unsuccessfully lobbied for the association to permit his dog Booster within the community as a pet. When he made the request, he didn't claim that he was disabled. Then a year later, after the pet request was denied, he had the same dog certified as a service animal, and then claimed for the first time that he was disabled and needed accommodation to keep Booster, the dog. For his alleged psychological disability, he provided a letter stating that for a long time before he had been abused, kidnapped, robbed, and assaulted by the stepson of a friend. Han argued that if Booster was in his condo unit and an intruder entered, Booster would at least make him aware of an intruder, summon help, and bring him the phone upon command. Han provided 2 letters about Booster's resume and his various certification records. The manager of the condo sent Han a letter asking for additional information that the board could consider for the request. No response was provided. Then the general manager wrote a letter to Han, again asking for documentation, including additional expert evidence under oath of the nature of your impairment. Now, that's something that would not fly today. The manner in which it substantially limits one or more of your major life functions or activities, and how the requested pet is necessary to afford you an equal opportunity to use and enjoy your dwelling, and if there are other corrective measures which would permit such use and enjoyment. Han didn't respond to that request. Instead, Han went and filed a complaint with the Florida Commission on Human Relations, who found that there was cause to believe that the defendants discriminated against him by not providing a reasonable accommodation. Han then filed the lawsuit alleging a violation of the Fair Housing Act, a violation of the Florida Fair Housing Act. Remember, that's part 2 of Chapter 760 of the Florida statutes, and intentional or reckless infliction of emotional distress. He also sought an injunction, which is just a court order to prohibit someone from doing something or to make someone do something. So this is the evidence that Hahn presented at trial. First letter was from a psychologist named Evans. The psychologist opined that Hahn suffered from severe panic attacks. Dr. Evans wrote that Hahn was unable to properly cope with anxiety and stress, and that he was particularly vulnerable while residing at his home/condo due to past occurrences on that property. The doctor wrote that he was prescribing a service animal to provide support to help Hahn cope with his emotionally crippling disability, and this included a brief description of what tasks Booster was able to perform, like bringing and removing his shoes and socks, opening the refrigerator, bringing him water, pulling him out of a chair, and as Seinfeld would say, or I'm sorry, Elaine, yada yada yada, and give him hugs to calm him after a panic attack. The second letter was from a chiropractor. The chiropractor wrote that he was intimately familiar with Hahn's history and the functional limitations imposed by his disability. Well, we were just hearing that the disability is something emotional, and now we're hearing from a chiropractor. Okay. The chiropractor opined that Hahn had certain limitations regarding mobility and that a support animal would assist with his disability. Now, this is what the court found regarding that first psychologist letter. Although the association could not have known at the time, the record showed that when the doctor signed the one-page letter, the entire treatment of the plaintiff consisted of 2 recent 1-hour counseling sessions. And during the second session, Hahn gave Dr. Evans the text or template for the letter that he wanted to be sent to the association. Dr. Evans testified during deposition that he used much of what Hahn wrote, although he probably made some changes. Again, this was a big gamble played by the association here, because this was not known at the time that the association, prior to trial. Regarding the chiropractor's letter, the court noted that the chiropractor made no attempt to explain what Hahn's purported limitations and disability were. The record reflected that at the time he signed the letter, the chiropractor had seen Hahn only 2 times. Specifically, he had examined the plaintiff once several years earlier and once shortly before he signed the letter to the board. For both visits, the chiropractor only performed examinations. He didn't render any treatment. And the chiropractor conceded at deposition that although he signed the letter, Hahn wrote the letter. Also, these doctors just fell apart at deposition, right? The outcome. So the court concluded that the board did not deny the request, but rather it asked Hahn twice to provide additional documentation, which he failed to provide both times. The board did not outright deny the request. It held a meeting, put the issue on the agenda, and allowed Hahn to give a speech in support. Given the lack of information that they had, and in light of the fact that Hahn had previously requested the animal as a pet, no reasonable juror could conclude that the board knew Hahn was disabled or handicapped when it made the decision to deny his request. Therefore, the court held that the association did not act improperly by requesting additional information. Now, it's certainly within the association's ability to ask for additional information. Again, we need to analyze, what do we know? Is it readily apparent? Does the association have information already in hand regarding the person's disability or the disability related need? If not, well, then the association can ask for documentation. The requirement that the documentation from the doctor be under oath, that's not going to hold any water today. But certainly there are rights for the association to ask for additional information. I'm going to skip through this next few slides just so that we can get to the little case studies under the Fair Housing Act. Some of these will be out of order. It's because the state case studies themselves are actually from our 2-hour lecture that we pulled into the 1-hour lecture. But at any rate, An applicant with an obvious mobility impairment who regularly uses a walker to move around asks her association to assign her a parking space near the entrance to the building instead of a space located in another part of the parking lot. Note that, yes, this is talking about a parking space, not an animal, but this goes to the same types of issues that we would analyze under an assistance animal request. So can the association require the applicant to provide additional information about her disability? Well, let's ask ourselves, what do we know? We know the person has an obvious mobility impairment. Well, if it's obvious, we don't need additional information. We know that she's disabled. So no, the association cannot require the applicant to provide additional information about her disability. Can the association require the applicant to provide additional information regarding her need for the requested accommodation? Well, let's look at her disability. It's mobility related, and she's asking for a parking space near the entrance to the building so that she doesn't have to walk so much. I think it's pretty obvious that there is a disability related need here for the closer parking space. A rental applicant who uses a wheelchair advises the association that he wishes to keep an assistance dog in his unit, even though the provider has a no pets policy. The applicant's disability is readily apparent, but the need for the assistance animal is not obvious to the provider. Can the association ask the applicant to provide information about the disability-related need for the dog? So we really need to check off our two boxes, right? Disability and disability-related need. Disability is readily apparent. We know he has a disability. He's in a wheelchair. But it's not obvious to the association why he needs the animal. So yes, the association can ask the applicant to provide information about the disability-related need for the dog. Because of his disability, an applicant with a hearing impairment needs to keep an assistance animal in his unit as a reasonable accommodation. Can the association charge an application fee? We already know. Nope, we cannot charge an application fee. Can the association charge a security deposit? Nope, the association cannot charge the security deposit. An owner in the association makes an oral request that she be assigned a mailbox in a location that she can easily access because of a physical disability that limits her ability to reach and bend. The association would prefer that the owner make the accommodation request on a pre-printed form, but the owner fails to complete the form. Must the association consider the reasonable accommodation request even though the owner did not use the association's designated form? Well, I hope you all are nodding yes, that the association must still consider the request even though they didn't use the form. Again, having the forms is very helpful for the association and for the person making the request. However, the association cannot require that the form be used in order to obtain that accommodation. A man who is substantially limited in his ability to walk uses a motorized scooter for mobility purposes. He applies to live in an association that prohibits the use of motorized vehicles. May the association deny the request to live in the association? Well, no, he can make his reasonable accommodation request. Must the association allow the applicant the use of his motorized scooter? Well, he has a disability and disability-related need for it, doesn't he? May the association charge the applicant a deposit as a security deposit against potential damage? No, we cannot. And that is essentially the end of this presentation. Unless there are some questions, I know that I've gone over a little bit. Let me stop the share here. But I don't know if there are some questions. Jeff, did you happen to pull up any questions that I can just briefly go through?
If I may, folks are not required to stay for the Q&A part. So let me just quickly go over the evaluation one more time while Courtney goes over a couple of the questions. Okay, so I'll do that. And I'll go over the evaluation a third time when you're through with everything even more slowly. So folks, in the chat area, we now have, we placed the link for the evaluation in there one more time. It'll take you here. Okay. And again, I'll do this more slowly after the Q&A. Fill this out. Question 4B is where you mention whether you need a certificate or not. Not everybody needs one, but some of you may want one. So that's where you let us know. After you hit the submit button, the confirmation screen looks like this. We'll email you a certificate if you requested one. You can click here to download the course material, the legislative guide we mentioned earlier, and both Danielle's and Courtney's contact and company information here at the bottom. I'll do that slowly again at the end. Back to you both.
All right, thank you so much. Danielle, thank you so much for your presentation. It was great. So while you were presenting, I did answer some of the questions. There
Okay.
are some that I left open because I didn't feel comfortable answering them. They're a little bit more detailed. So I'll read some off to you.
Sure.
Some of these questions, really, a lot of people had more questions specifically regarding emotional support animals. Some of the questions were, can the association make like rules against like, so if a dog specifically is labeled an emotional support animal, if the community has rules on the size and the breed restrictions, and that emotional support animal does not fit that criteria, is that allowed? Are they allowed?
Yes. So if you have weight, number, breed restrictions for animals, those restrictions are not going to apply for your assistance animal. So let's say, I hate to pick on them, but they do get picked on all the time, pit bulls.
Pit bulls, yeah.
A community prohibits pit bulls, but my emotional support animal is a pit bull. Well, so long as I have shown, either being readily apparent or by documentation that I have a disability and a disability related need for that animal, I am entitled to have the animal within the community. So those restrictions are not going to apply to your assistance animals. Now, there are, when it comes to adopting rules and regulations governing assistance animals, again, you're going to have to go to your association's attorney, make sure you first have the authority to adopt rules and regulations, and then consider, okay, why are we adopting these rules? What type of rules do we want to impose? Is it reasonable to do this? And then, if you do adopt them, you do have to consider, okay, are there going to be requests for reasonable accommodations to the rules that we're putting into place? So, it really is something that you need to address specifically for your community.
Gotcha. A few other questions. So there's a good one. Someone stated, can you shed light on if a resident has a true legitimate illness and letter from the doctor which states the resident cannot pick up dog waste? Does the HOA have the legal responsibility to pick up the dog waste on behalf of the resident?
So we're looking at an accommodation for a rule, presumably you have a rule which requires that the person pick up animal waste from their assistance animal. And now they're making a request for an accommodation to that assistance animal poop pickup requirement. Now, I've never seen a letter state that a person's disability prohibits them from picking up after their animal.
Well, maybe somebody has like a back industry.
Unless it's right, unless it's something physio, like your actual body. I don't know of anything that
I know, that's why I
prohibit someone. But let's assume that it's all legitimate, right?
Yeah.
Then I think you would be required to provide an accommodation to that and would not be able to enforce the poop pickup requirement against that person.
Yeah, that makes sense. Another one, I have a resident that says a service animal was registered with a husband. The husband passed away. So now the spouse is keeping the dog, and the spouse has not provided documentation. It's labeled as an emotional support animal. They have not provided the documentation or made the request. So is that something that they can ask for that documentation?
Yes.
A new, okay.
Yeah.
So yes, Lori, if you heard that, yes, you can ask for documentation from the wife.
Yeah, because remember that the request and the what's been granted is specific to the person and specific to the animal.
I was
So when the person,
sorry, I was just going to say, I was pretty sure that was the answer, but I didn't want to be wrong and say, I don't, you know.
Yeah, so, I mean, if the person who was disabled for which the accommodation was granted in the first place is no longer there, but the animal still is, well, then I think the association is within a reasonable position to ask for documentation to stay okay. You know, the animal, these are the circumstances. We are a pet prohibited community, considering that the person who is disabled needing this animal has since passed. You know, this animal is now considered a pet unless there's some type of documentation that you are disabled and have a disability related need for the animal.
Yeah. Okay, 2 more questions if you can.
Sure.
And you may have answered this one, but I also wanted more clarification. If a unit owner or resident has 3 dogs, do they need a letter from their medical doctor on 3 separate handicaps or disabilities?
Okay, so not as to the disability, but as to the disability related need or service that's provided by that particular animal. And this actually, you know, the HUD guidance isn't so specific. You know, it says that usually the request is for 1 animal, but it could be for multiple animals. Florida law is better at answering this question when it comes to multiple animals, to say that each animal needs to provide its own service or perform its own tasks or do its own work for whatever the person's disability is. So no, they don't have to have 3 different disabilities in order to have the 3 animals, but each animal should have its own work or tasks or service that it provides to aid the person with their disability.
Okay. Another quick question. Can someone have, because it kind of relates to the last one, but more for the emotional support, can someone have 3 or more emotional support animals? Can you if somebody's like, well, I have an emotional support dog, and then they want to go get another dog, can they say that dog's an emotional? Can they keep saying that every single dog that they have is an emotional support dog? Is there a cap or a limitation?
Though there isn't. The way that the laws are structured now, there is no limitation. Again, there needs to be, under Florida law, there needs to be a task or service that each animal provides. But if they can continue substantiating the disability related need for that particular animal, then presumably they can have as many assistance animals that they need.
Okay, that makes, all right. I hope that answers the question. And then there is one more. I'm so sorry. There was a good one and I lost my area.
Take your time. We appreciate it.
This is a good one. So does a person visiting a condo and does not live there have the right to bring an emotional support animal when visiting or staying for a few days? The person claims the animals are emotional support. The condo is a no pet community and owners can only have 1 small pet. Well, then it wouldn't be a no pet community, but regardless, can non-residents bring their emotional support animals to the association or the unit? Do they have to provide any documentation? Can the association
all of that? Yes. So this would extend to guests, and the association would still be in a position to request documentation if the disability or disability related need are not known or readily apparent to the association. So same thing applies.
Okay. And then just one clarification, because I think people are getting confused about the assistant animal, emotional support. Emotional support animal is an assistant animal, correct?
Yes.
So Tammy.
So assistance animal is the name that we give to both service animals and support animals more commonly referred to as emotional support animals.
Okay, so an assistant, so Tammy, I know you've asked a few questions. Assistant animals is related to the emotional support animal. So that what she had said about the size and the limitation of how many you can have, that does apply to the emotional support question you asked. There are a few more, but I don't want to take up any more of anybody's time. I will just say that if anybody has any additional questions, you can always reach out to me via email. I am not an attorney, though. I am not a licensed attorney. I am a licensed association manager. So I answered all of the questions to the best of my ability, but take what I say with a grain of salt. I always say this, your best bet is to go to your own association attorney. Some of these questions are very, very simple. I don't think it would take your association attorney a ton of time to answer them. I get it as a board member myself. I get people, I think what happens is people are afraid to go to the association attorney for things, even simple things, because their time is money. And I get that, but these questions are very, very simple and any attorney can answer them. And it's better to have their answer than somebody that's not 100% sure. That's why I saved some of your questions for when Danielle was available, because I'm not 100% sure. So
and
again,
having advice of counsel is actually a really good thing that you guys can hide behind when you're taking action. If you have that opinion letter in hand as the board association board, you can use that and rely upon that when taking action. Anyway.
Yeah.
no,
And,
thank you for that. Yes.
and trying to do more for less now, like not paying to get that proper opinion can cost
Right.
you a lot
Yes.
more later.
Yes, it
So
can.
do it right the first time.
Do it right the first time. So again, thank you so much, Danielle. I
Thank
really
you.
appreciate your webinar. You were great. I hope we work together again. You can find more information about Danielle on the Kaye Bender Rembaum website, kbrlegal.com. You're at the gardens, you're at the Palm Beach Garden, you work out of the Palm Beach Gardens office, great office. So thank you again so much. And
Thank you.